The course pack, which was the subject of this case, had about 6 works in them. And if you go through the list, you can see why the court eventually held for the plaintiffs. One of them, I'll just go through a few of them. One of them was Farewell to the Party of Lincoln, Black Politics in the Age of FDR. It was 95 pages were copied, which was 30%. Another one was Walter Lippmann's Public Opinion, which was 45 pages, representing about 18%. There was a fair amount of copying there. And so the court held, by the majority at least, that the course pack producer, although he said this was for educational purposes, was charging students for the course pack. And it was, and he was detracting from the revenue stream. In so doing, it's rather interesting that the Court of Appeals relied primarily on the 4th factor. I've gone through these 3 factors, the first 3 and the 4th. We have to because that's by act of Congress. But the Court of Appeals at that time relied on the 4th factor. The court said the 4 statutory factors may not have been created equal. Well, I think he meant to say applied equally. In determining whether use is fair use, the Supreme Court has said that the most important factor is the 4th. That is the effect on the revenue stream and the potential revenue stream. And therefore, the court noted that although Mr. Smith may have been selling it to students to be used in a nonprofit educational institution, it was for commercial purposes, and also it detracted from the revenue stream. So it relied primarily on the 4th factor. In fact, the court said that the Supreme Court, the Court of Appeals noted that the Supreme Court has said that one need only show that if the challenged use should become widespread, it would adversely affect the potential market for the copyrighted work. Well, effectively, the Court of Appeals relied only on the 4th factor. However, there are some subsequent cases that have held that all 4 factors should be taken into account because if that were the case, only the 4th factor, then the Congress would have, it would be superfluous to have the 3 factors. Well, some other cases did address all 4 factors, and the next case in which the fair use defense was rejected the fair use defense was sustained was in Kelly versus Ariba Software. In Princeton University Press, the fair use defense was rejected. In Kelly versus Ariba Software, the fair use defense was sustained. The Kelly versus Ariba Software was the work that was involved were pictures of the American West. And I spoke to Leslie Kelly, the photographer, about a few weeks ago. I got some emails from him. He was kind enough to send me some of the pictures that he uses, and I hope I have them correctly. Here's one of the pictures. He said these are beautiful pictures of the American West. Another one of his photographs. Here's a third one. This is one, apparently he got this from some archives, but maybe he digitized it. He imparted some color to it. So he produced pictures of the American West, and he posted them up on his website. He sold some of them and even licensed it to some people. Ariba was a search engine, something we'll do some talking about. Ariba provided some what they referred to as thumbnails. This was a picture that Mr. Kelly provided to me, which shows it's kind of a fuzzy picture. There's a picture of what's supposed to be a prospector. This was one which was introduced at the trial level. If you can, as you will note, he states that, or his attorney stated in the trial exhibit, by clicking on the box adjacent each thumbnail of Kelly's image and then clicking on the download to Ariba Express, the Ariba Express user could simply download the full-size copyrighted registered image without asking for permission or even visiting Kelly's website. Well, that may be true. However, if you notice, this picture was kind of fuzzy, and Ariba did not sell pictures in competition with Mr. Kelly. Ariba just provided a search engine so that, but Mr. Kelly was the one who was selling these beautiful pictures of the American West. When Mr. Kelly sued Ariba Software based on its search engine, Ariba asserted the fair use defense. Now, it should be kept in mind that Ariba was a for-profit organization. They were selling some advertising spaces. They wanted to make money. They did not sell, though, however, pictures in competition with Leslie Kelly. Ariba asserted the fair use defense, and the Court of Appeals eventually held for Ariba. In this case, the Court of Appeals acknowledged that it's necessary to analyze all of the 4 fair use factors. And in fact, it did acknowledge the 4 fair use factors. This case was decided in 2003. And then in analyzing the first factor, it discussed the purpose and character of the use. And in this case, the court held for Ariba. The purpose of this was mostly for internet search purposes. This benefits the public by enhancing information gathering techniques on the internet. So that was really the purpose and character. The court then went on to discuss the second factor, the nature of the copyrighted work. Now this favored Leslie Kelly rather slightly, because the court said that, well, these are very aesthetically appealing pictures. They look rather pretty, so slightly in favor of Kelly. Now, the court then discussed the issue of the amount and substantiality of the portion used. As we'll see, this is the thumbnail that was used, and it was kind of a fuzzy picture. Mr. Kelly said, you know, they could have like cut it in half or sliced it or just shown part of it. And Ariba's contention was, well, if you cut it in half, you don't have the benefit of the internet search engine. He's just showing enough. And when it's expanded, it's still a fuzzy picture, certainly nothing in competition with that beautiful picture. Like here is that beautiful picture of the American West. I'm not trying to sell that. All I'm trying to sell is the internet search engine services. So the court held that this factor was slightly the nature of the copyrighted work and the amount of substantiality. The court held that this factor was sort of like neutral. The court then discussed the third factor, that is the amount and substantiality of the portion used. And, well, this was a neutral factor. The factor that the court also, I should mention, is the nature of the copyrighted work, because it's rather aesthetic, so this favored Kelly slightly. The court then, however, went on to the fourth factor, which is the one that it relied on the most. That is the effect of use upon the potential market for or value of the copyrighted work. And in this instance, the court held clearly for Ariba. The court said that by showing thumbnails on its results page when users entered terms related to Kelly's images, the search engine would guide users to Kelly's website rather than away from it. The thumbnails would not be a substitute for the full-sized images because the thumbnails lose their clarity when enlarged. What that means is that users would not go to Ariba to purchase the picture that they could purchase from Leslie Kelly. And the users would also get this just fuzzy picture. So in this case, we can see that there wasn't this, this detraction of revenue from the plaintiff that we saw in the case of Michigan University Press versus, Princeton University Press versus Michigan Documents. In that case, there was a revenue stream that Michigan Documents detracted from the publishers. In this case, Ariba Software was not detracting revenue from the copyright owner.